The Jefferson County Courthouse in downtown Charleston, South Carolina, stood as an imposing monument to justice, at least in theory. Built in 1896 during the Reconstruction era, its neoclassical architecture featured towering Corinthian columns and intricate moldings that spoke of order, tradition, and permanence. The building had weathered hurricanes, political upheavals, and social transformations, yet some things within its walls remained stubbornly unchanged. For 24 years, Courtroom 5B on the third floor had been the domain of one judge, Judge Eleanor Sullivan. Her reputation hung in the air like the musty scent of old law books that lined the mahogany shelves behind her bench. The room itself was a study in contrasts, opulent in its architectural details yet austere in its functionality. Sunlight filtered through tall windows with wavy, aged glass, casting patterns across the worn wooden benches where defendants and their families waited, often in vain, for mercy. Outside, Charleston's summer heat pressed against the building like a physical force. But inside, the air conditioning hummed with icy efficiency, a metaphor, perhaps, for the cold justice dispensed within. Marcus Johnson straightened his burgundy tie in the men's room mirror, studying his reflection with critical eyes. At 45, his close-cropped hair had begun showing flecks of gray at the temples, lending him a distinguished appearance that served him well in the courtroom. His charcoal suit was impeccably tailored, his white shirt crisp and spotless. In his profession, appearance mattered, especially for a black defense attorney in the South. "You ready for this?" asked Terrence Washington, a younger colleague who had joined Marcus at the sink. Marcus's eyes met Terrence's in the mirror. "As ready as anyone can be for Judge Sullivan." Terrence winced. "Man, I don't envy you. That woman's got ice in her veins." "And something else, too," Marcus replied, his voice dropping to a near whisper despite the empty bathroom. 24 years on the bench, and her conviction rates for black defendants are nearly twice that of white defendants with similar charges. "Everybody knows it," Terrence agreed. "But knowing it and proving it," Marcus nodded grimly. "That's always been the problem." As he gathered his leather briefcase and prepared to leave, Terrence placed a hand on his shoulder. "Just keep your cool in there. Sullivan hates nothing more than a defense attorney who challenges her authority." "I'm well aware," Marcus replied, memories of previous encounters with the judge flashing through his mind. "But today might be different." The confidence in his tone made Terrence raise an eyebrow. "You got something up your sleeve?" Marcus allowed himself a small smile. "Let's just say I've been doing my homework." Walking through the courthouse corridors, Marcus nodded to familiar faces, other attorneys, bailiffs, court reporters, people who, like him, had spent years navigating the complex ecosystem of the justice system. Some returned his greeting warmly, others with reserved politeness, and a few barely acknowledged him at all. Such was the reality of being one of the few black attorneys who regularly practiced in these courts. Marcus had grown up in North Charleston, in a neighborhood where interactions with the legal system were common but rarely positive. His father, a postal worker, and his mother, an elementary school teacher, had instilled in him a deep respect for education and an even deeper skepticism of institutions that claimed to treat everyone equally. When he announced his intention to become a lawyer after a cousin was wrongfully convicted on flimsy evidence, his parents had been both proud and afraid. Proud of his ambition, afraid of the barriers he would face. Those barriers had been substantial, but not insurmountable. After graduating from Howard University School of Law with honors, Marcus had returned to Charleston, determined to be the advocate his community needed. For 18 years, he had built a reputation as a formidable defense attorney who took on cases others deemed hopeless, and sometimes, against all odds, won them. But Judge Eleanor Sullivan had been a thorn in his side throughout his career. She was known for her harsh sentences, her dismissive attitude toward defense motions, and her barely concealed contempt for attorneys who represented clients she had already decided were guilty. Sullivan, a tall, slender woman with steel-gray hair always pulled into a tight bun, came from old Charleston money. Her father and grandfather had been judges before her, and her appointment to the bench had seemed predetermined since her graduation from the University of Virginia Law School. At 68, she had the bearing of someone who had never questioned her place in the world or her right to judge others. As Marcus approached courtroom 5B, he saw Rebecca Chen, his paralegal, waiting outside with several folders clutched to her chest. At 32, Rebecca had worked with him for 5 years, proving herself invaluable with her meticulous research skills and unflappable demeanor. "Everything ready?" he asked quietly. Rebecca nodded, her expression serious. "It's all here. But Marcus, are you sure about this? Judge Sullivan isn't someone you want as an enemy." "She's already my enemy," Marcus replied evenly. "Has been since the first time I questioned one of her rulings." He took the folders from Rebecca, his fingers briefly lingering on a particular one marked with a red tab. "Is the information verified?" "Triple-checked," Rebecca confirmed. "Sources are solid. Once you bring this up, though, there's no going back." Marcus took a deep breath, steadying himself. "Some things are worth the risk. This case is one of them." The case in question involved James Wilson, a 23-year-old black man accused of armed robbery. The evidence was circumstantial at best. A grainy security camera image that showed someone of similar height and build, a witness identification made under questionable conditions, and a prior conviction for a non-violent offense that the prosecution was using to establish pattern. Under a fair judge, Marcus would have been confident in his ability to create reasonable doubt. But with Sullivan presiding, James's chances were slim. Unless Marcus could change the game entirely. The heavy wooden doors of courtroom 5B loomed before him, polished to a high shine that reflected distorted versions of those who approached. Marcus straightened his shoulders, gripped his briefcase firmly, and pushed through. The courtroom fell into a hushed silence as Marcus entered. Though the day's docket was full, courtroom 5B was never particularly noisy. Sullivan had a reputation for holding spectators in contempt, if they so much as whispered during proceedings. The gallery was divided by an invisible line. On one side sat the friends and family of defendants, predominantly people of color. On the other, court observers, law students, and the occasional reporter. At the prosecution table sat District Attorney Richard Hargrove, a man whose political ambitions were an open secret. At 52, Hargrove had his sights set on the State Attorney General's office, and his tough-on-crime stance had won him both admirers and critics. His assistant, Vanessa Miller, a sharp young prosecutor barely 5 years out of law school, sat beside him, meticulously organizing documents. James Wilson, Marcus's client, was already seated at the defense table, his orange jumpsuit a stark contrast to the muted tones of the courtroom. Despite Marcus's repeated requests, Sullivan had denied pretrial release, citing James's danger to the community based on a 7-year-old juvenile record that should have been sealed. Marcus placed a reassuring hand on James's shoulder as he took his seat, noting the young man's tense posture and the dark circles under his eyes, evidence of sleepless nights in the county detention center. "All rise." The bailiff's voice cut through the room as a side door opened and Judge Eleanor Sullivan emerged, her black robe flowing around her as she ascended to the bench. "Be seated," she commanded without looking up, already flipping through papers as if the humans before her were mere distractions from the real business of the day. When she finally raised her eyes, they swept across the courtroom with practiced indifference until they landed on Marcus. Something flickered across her face. Annoyance, perhaps, or resignation at having to deal with him again. "Mr. Johnson," she said, her voice carrying that particular tone she reserved for him. Formal, cold, with an undercurrent of disdain. "I see you're representing Mr. Wilson." "Yes, Your Honor," Marcus replied, keeping his voice neutral. Sullivan's gaze shifted to James, assessing him briefly before returning to her papers. "Let's proceed efficiently today. I have a full docket." Marcus felt a familiar tension creep up his spine. Sullivan's idea of efficiency typically meant rushing through defense arguments while giving the prosecution ample time to present their case. But today, he reminded himself, would be different. The proceedings began with Hargrove presenting his case for holding James without bail until trial, a standard practice in Sullivan's courtroom for certain defendants, despite clear statutory guidelines suggesting otherwise. Hargrove's argument was polished but thin on legal substance, relying heavily on inflammatory language about career criminals and threats to public safety. When it was Marcus's turn to speak, he rose slowly, deliberately, feeling the weight of all eyes upon him. "Your Honor, the prosecution's characterization of my client is not only prejudicial, but factually incorrect. Mr. Wilson has one prior conviction for a nonviolent offense, for which he has completed probation successfully. He has stable employment, community ties, and is not a flight risk." Sullivan watched him over the rim of her reading glasses, her expression making it clear she had already made her decision. "Mr. Johnson, spare us the character reference. The court is well aware of Mr. Wilson's history." "With all due respect, Your Honor," Marcus continued, undeterred, "I don't believe the court is taking into account the full context of Mr. Wilson's situation. Furthermore, the prosecution has failed to share key exculpatory evidence with the defense, in direct violation of Brady v. Maryland." A murmur rippled through the courtroom. Sullivan's eyes narrowed dangerously. "What evidence are you referring to, Mr. Johnson?" "Security footage from a gas station 2 blocks from the alleged robbery shows my client at the time the crime was committed. The prosecution has had this footage for 3 weeks, but has failed to disclose it to the defense." Hargrove stood abruptly. "Your Honor, we have no such footage in our possession." Marcus reached into his briefcase and withdrew a DVD in a clear case. "I have it here, Your Honor. A copy was sent to the DA's office on May 7th, as our receipt shows." He held up another document. "This evidence conclusively establishes that Mr. Wilson could not have committed the robbery." Sullivan's face tightened. "Mr. Johnson, why are you bringing this up now, instead of through proper channels?" "Because, Your Honor, this is not the first time exculpatory evidence has mysteriously failed to reach the defense in cases before your court. In fact, I have documented 17 instances over the past 5 years where critical evidence favorable to defendants of color was misplaced or overlooked by the prosecution, with Your Honor consistently ruling against defense motions for disclosure." The courtroom fell completely silent. Sullivan's face had gone pale, then flushed with anger. "Mr. Johnson, you are bordering on contempt." "I'm simply stating facts supported by evidence, Your Honor," Marcus replied evenly. "And in light of these facts, I move for immediate dismissal of all charges against Mr. Wilson and an investigation into the pattern of Brady violations in this court." Sullivan's hand tightened around her gavel. "Motion denied. Mr. Johnson, I suggest you watch your tone and your accusations very carefully." Marcus had anticipated this response. It was, after all, exactly the reaction he needed to proceed with his plan. "Then I must formally request Your Honor's recusal from this case on the grounds of demonstrated bias." Recusal denied, Sullivan snapped, her patience clearly evaporating. Mr. Johnson, one more word and I will hold you in contempt. Marcus took a deep breath. This was the moment he had prepared for, the point of no return. Your Honor, before you make that ruling, you should know that I have evidence of judicial misconduct that goes far beyond bias in individual cases. At that precise moment, the courtroom doors opened, and two individuals in dark suits entered, moving with the purposeful stride of federal agents. The woman in front, African American, with close-cropped hair and an air of unquestionable authority, approached the bench directly. Judge Eleanor Sullivan, she announced, holding up credentials. I'm Special Agent Tanya Roberts with the FBI. We need to speak with you immediately. Sullivan, for perhaps the first time in her career, appeared genuinely shocked. This is my courtroom, and I am in the middle of proceedings. Whatever this is about will have to wait. Agent Roberts shook her head. I'm afraid it can't wait, Your Honor. We have a federal warrant for your arrest on charges of judicial corruption, civil rights violations, and obstruction of justice. The courtroom erupted in gasps and murmurs. Sullivan's face drained of color as she stared first at the agents, then at Marcus, comprehension dawning in her eyes. You, she whispered, her voice barely audible over the growing noise. Marcus met her gaze steadily. Justice delayed is justice denied, Your Honor. Some of us have been denied for far too long. The events that led to Judge Eleanor Sullivan's arrest had begun 18 months earlier, though the seeds had been planted throughout Marcus Johnson's career. Each time he had stood before her bench and watched justice bend to prejudice, each time he had consoled clients sentenced more harshly than their white counterparts for identical crimes, each time he had filed appeals that were summarily dismissed. These moments had accumulated like evidence in a case file Marcus had never officially opened, but had always kept in the back of his mind. The catalyst came in the form of Michael Torres, a former clerk who had worked in Sullivan's chambers for 3 years before being abruptly terminated. Torres had approached Marcus after a particularly contentious hearing, waiting for him in the courthouse parking garage as evening shadows lengthened across the concrete. Mr. Johnson, Torres had called out, startling Marcus as he unlocked his car. I need to talk to you about Judge Sullivan. Marcus had been wary. Such approaches could be setups or traps, but something in Torres's expression had convinced him to listen. Over coffee in a quiet diner 20 miles outside Charleston, Torres had revealed a pattern of behavior inside Sullivan's chambers that went beyond bias into the realm of corruption. He spoke of altered transcripts, of ex parte communications with prosecutors, of explicit instructions to schedule certain defense attorneys, particularly those representing minority clients, for inconvenient times or before holidays when Sullivan knew juries would be eager to reach quick verdicts. Most damning of all, Torres produced a personal journal he had kept during his employment, documenting specific instances, dates, and cases where Sullivan had made overtly racist comments about defendants and their attorneys, including Marcus himself. She called you an uppity Howard graduate who needs to be reminded of his place, Torres had said, his voice low despite the empty diner. That was after you won the Williams case on appeal. Marcus had felt a cold anger settle in his stomach, but he had kept his expression neutral. Why are you telling me this now, Mr. Torres? Why not when you were still working there? Torres had looked down, shame evident in his posture. I needed the job. I have student loans, family obligations, and I was afraid. Sullivan has connections everywhere in the legal community here. Cross her, and you might never work in law again. He had paused, then added, but I couldn't live with myself anymore. Not after what happened to that kid last month. the one who got 15 years for a first-time drug offense when the white college student in the exact same situation got probation. Marcus knew the case Torres was referring to. He had represented the white defendant, who came from a wealthy Charleston family. The black defendant had been represented by a public defender and had appeared before Sullivan the following week. The disparity in sentences had been so egregious that even veteran courthouse staff had commented on it. "What do you want me to do with this information?" Marcus had asked, though he already knew the answer. Torres had met his eyes. "Whatever it takes to stop her. I'll testify if necessary." That meeting had set in motion a careful, methodical investigation. Marcus had reached out to other former clerks, court reporters, and attorneys who had practiced before Sullivan. Some had been eager to share their experiences. Others had been reluctant until assured of anonymity. Bit by bit, a picture had emerged of a judge who not only harbored deep-seated prejudices, but actively manipulated the judicial system to satisfy them. The breakthrough had come when Rebecca Chen, through painstaking statistical analysis, had documented irrefutable patterns in Sullivan's rulings. Black defendants received sentences averaging 40% longer than white defendants for identical crimes. Motions filed by black attorneys were denied at 3 times the rate of those filed by white attorneys. Evidentiary rulings consistently favored prosecution when the defendant was a person of color. With this data and testimonial evidence in hand, Marcus had approached the FBI's Civil Rights Division rather than local authorities, knowing that Sullivan's connections might impede any investigation originating in Charleston. Special Agent Tanya Roberts had taken the lead, bringing a fresh perspective as someone outside the insular Charleston legal community. For 6 months, the investigation had proceeded in absolute secrecy. Wiretaps had been authorized, revealing Sullivan's inappropriate communications with certain prosecutors. Financial records had shown suspicious deposits coinciding with favorable rulings in cases involving wealthy defendants. Former defendants had come forward with stories of apparent collusion between Sullivan and private prison contractors who benefited from her high incarceration rates. The decision to arrest Sullivan in open court had been strategic rather than theatrical, a rare instance where the FBI agreed that justice needed to be seen as well as served. The public nature of the arrest would prevent any possibility of evidence disappearing or witnesses being pressured into silence. As Sullivan was led from the courtroom in handcuffs, her face a mask of cold fury, Marcus had felt no triumph, only a solemn acknowledgement that one piece of a broken system was finally being addressed. James Wilson, bewildered by the sudden turn of events, had turned to Marcus. "What happens now?" "Now," Marcus had replied, "we start rebuilding what she destroyed." The weeks following Sullivan's arrest transformed the Charleston legal community. What had begun as shock quickly evolved into a complex mixture of reactions: denial from some quarters, vindication from others, and a pervasive sense of institutional soul-searching that transcended individual cases. For Marcus, the aftermath brought both professional challenges and personal revelations. His role in the investigation made him simultaneously a hero to many and a pariah to those who had benefited from Sullivan's regime. Death threats arrived at his office. So did flowers, cards, and visits from former clients who finally understood why their cases had gone so poorly despite his best efforts. 3 weeks after the arrest, Marcus sat in his office reviewing case files. Sullivan's indictment included charges related to 57 specific instances of judicial misconduct, but Marcus knew there were hundreds more cases that deserved review. The question was how to address this massive injustice efficiently within a system already burdened by backlogs and bureaucracy. A knock at his door interrupted his thoughts. Rebecca stood there, tablet in hand, looking simultaneously exhausted and energized. "You need to see this," she said, placing the tablet in front of him. On the screen was an email from the state Supreme Court. In light of recent events concerning former Judge Eleanor Sullivan, the South Carolina Supreme Court hereby establishes a special review panel to examine all cases over which she presided during her tenure. Marcus read quickly, his heart rate accelerating as he grasped the implications. The panel would prioritize cases involving defendants still incarcerated, with particular attention to sentencing disparities and alleged Brady violations. Most significantly, the panel would include defense attorneys, prosecutors, academics, and community representatives, a balanced approach rarely seen in such reviews. "This is unprecedented," Marcus murmured, scrolling through the detailed procedures outlined in the document. "There's more," Rebecca said, swiping to the next screen. "You've been invited to serve on the panel." Marcus looked up sharply. "Me? They want the man who brought down a judge to help review her cases?" "Actually, it seems like that's exactly why they want you. Your name was specifically recommended by Justice Washington." Marcus sat back, momentarily speechless. Justice Elaine Washington was the only black woman on the state Supreme Court, a brilliant jurist whose elevation to the bench 5 years earlier had been heralded as a step toward a more representative judiciary. That she would personally recommend him spoke volumes about the shifting winds in Charleston's legal establishment. Another knock drew their attention to the door, where Terrence Washington stood, grinning broadly. "I see you got the news. Congratulations, man. It's a big deal." Marcus gestured for him to enter. "It's a lot to process. What are people saying at the courthouse?" Terrence's expression sobered. "It's mixed. Most people are keeping their heads down, trying to figure out which way the wind is blowing. But there's a faction, mostly older judges and some of the career prosecutors, who think this is all a witch hunt. They're saying Sullivan made technical errors at worst, not criminal ones." "Technical errors," Marcus repeated with a bitter laugh. "Is that what we're calling systemic racism and corruption now?" "You know how it goes," Terrence replied with a shrug. "Nobody wants to admit they were part of the problem, or that they looked the other way for years. But here's something interesting. Judge Robertson pulled me aside this morning." Marcus raised an eyebrow. Judge William Robertson was known as one of the more conservative jurists on the bench, a man who had rarely, if ever, disagreed publicly with Sullivan. "He wanted me to tell you he's available to talk off the record. Said there are things about Sullivan you should know that haven't come out yet." Marcus exchanged a glance with Rebecca. "That's unexpected." "Rats fleeing a sinking ship," Rebecca suggested. "Maybe," Terrence conceded. "Or maybe he genuinely wants to help clean up the mess. Either way, it can't hurt to hear what he has to say." Marcus considered this as his phone buzzed with an incoming call, Special Agent Roberts. He answered, putting the call on speaker. "Mr. Johnson," Roberts began without preamble, "we need to discuss security arrangements for you and your family. We've intercepted communications suggesting that certain individuals are unhappy with your role in Judge Sullivan's case." Marcus felt a chill despite the warm office. "How credible are these threats?" "Credible enough that we're taking them seriously." Sullivan had connections beyond the courthouse. Business interests, political allies, people who benefited from her selective application of justice. Some of them stand to lose a great deal if her cases are overturned. After discussing specific precautions and agreeing to a security assessment of his home and office, Marcus ended the call, feeling the weight of his actions settling more heavily on his shoulders. "Are you having second thoughts?" Rebecca asked quietly. Marcus gazed out his office window at the Charleston skyline, the church steeples and historic buildings that made the city famous. No, he said finally. But I'm more aware than ever that what we're doing isn't just about Sullivan. It's about a system that allowed her to flourish for 24 years. Changing that will be harder and more dangerous than bringing down one corrupt judge. Later that afternoon, Marcus met Judge Robertson at a private club on the outskirts of the city. The Palmetto Club had once been notorious for its exclusionary policies, barring black members until a lawsuit in the 1990s forced integration. Even now, Marcus was one of only a handful of black members, his inclusion more a reflection of professional necessity than social acceptance. Robertson, a heavy-set man in his 60s with a shock of white hair and perpetually flushed cheeks, sat in a corner booth, nursing what appeared to be bourbon. He nodded curtly as Marcus approached, but didn't rise. "Johnson," he said by way of greeting, "appreciate you coming." "Judge Robertson," Marcus replied, sliding into the opposite seat. "You wanted to talk about Sullivan." Robertson glanced around before leaning forward. "What you've uncovered is just the surface. Sullivan's prejudice wasn't limited to the courtroom. It was part of a broader network of influence and corruption that's been operating in Charleston for decades." For the next hour, Robertson outlined connections between Sullivan, certain property developers, private prison contractors, and political figures, a web of relationships that had enriched all involved at the expense of justice. He named specific cases where outcomes had been predetermined, bribes exchanged, evidence manufactured or suppressed. "Why are you telling me this now?" Marcus asked when Robertson finally paused. "You sat beside her on the bench for 15 years. You must have known what was happening." Robertson's face darkened with what might have been shame. "I did. Not all of it, but enough. And yes, I looked the other way." "Why?" "At first, because it was easier. Later, because I was implicated too deeply to extricate myself." Robertson took a long swallow of his drink. "I'm not proud of it, Johnson. I let myself become part of something I knew was wrong, because the alternative meant sacrificing my career, my reputation, possibly my freedom. And now? Now I'm old. I have cancer, 6 months, maybe a year left. I don't want whatever legacy I have to be entirely defined by my cowardice." He slid a flash drive across the table. Names, dates, case numbers, bank transactions. Everything I could remember or find documentation for. It won't absolve me, but maybe it will help undo some of the damage. Marcus pocketed the drive. "This could implicate you in criminal activity." Robertson smiled thinly. "I'll likely be dead before any prosecution reaches me. But yes, I'm aware of the risk." As Marcus prepared to leave, Robertson added, "One more thing. Sullivan isn't done fighting. She has resources, connections outside Charleston. Watch your back." 2 days later, Marcus received a call from Agent Roberts confirming Robertson's warnings. The FBI had uncovered evidence of a sophisticated operation to discredit the investigation, including plans to plant false evidence suggesting Marcus had fabricated claims against Sullivan for personal gain. "We're staying ahead of it for now," Roberts assured him. "But it's clear that powerful interests are aligned against this investigation." "What about James Wilson and the other defendants still incarcerated from Sullivan's cases?" Marcus asked. "They're the most vulnerable in all this. The U.S. Attorney's Office is expediting reviews, but it's a slow process. The system isn't designed for rapid corrections." The irony wasn't lost on Marcus. Justice delayed was indeed justice denied, and the very bureaucracy that had allowed Sullivan's corruption to flourish was now impeding efforts to remedy it. That evening, as Marcus reviewed case files in his home office, his teenage daughter Zoe appeared in the doorway, concern evident in her expression. "Dad, there's someone watching our house. A car across the street that's been there for hours." Marcus immediately contacted the security detail Agent Roberts had arranged. Within minutes, the suspicious vehicle was approached by unmarked cars, but the driver sped away before being identified. It might have been nothing, Marcus told his wife, Angela, later that night. Just a coincidence. Angela, a pediatrician whose pragmatism complemented Marcus's idealism, gave him a look that said she wasn't fooled. This isn't nothing, Marcus. You've challenged powerful people, and they're pushing back. Should I stop? Back off from the review panel, let someone else carry this forward? Angela considered the question seriously. Could you live with yourself if you did? The answer came without hesitation. No. Then you continue. But we take every precaution, and you tell me everything. No protecting me by keeping secrets. She took his hand, her grip firm. We knew when you chose this path that it wouldn't be easy. The only question that matters is whether it's right. The next morning brought news that reverberated through Charleston and beyond. Judge William Robertson had been found dead in his home, an apparent suicide. A note found with his body reportedly stated, "I choose the timing of my accounting, if not the fact of it." When the flash drive Robertson had given Marcus proved to contain exactly the evidence he had promised, the investigation expanded exponentially, drawing in figures from across Charleston's power structure. Within weeks, 2 state legislators, a county commissioner, and the CEO of a private prison company had been indicted along with Sullivan. For James Wilson, the developments brought long-awaited justice. The charges against him were dismissed with prejudice, and he became one of the first plaintiffs in a class-action civil rights lawsuit against the county and state. But for Marcus, the widening scandal confirmed what he had long suspected, that Sullivan's corruption was not an aberration, but a symptom of deeper systemic failures. As summer gave way to fall, the special review panel established by the state Supreme Court began its methodical examination of Sullivan's cases. The process was painstaking, emotionally fraught, and occasionally contentious as panel members debated the extent of Sullivan's influence and the appropriate remedies for different types of misconduct. Marcus found himself in the unique position of being both an architect of Sullivan's downfall and an advocate for her victims. The dual role took a toll, physically and emotionally, but it also afforded him unprecedented insight into the machinery of justice and the possibilities for reform. 1 year after Judge Eleanor Sullivan's dramatic arrest, Marcus Johnson stood before a different judge in a different courtroom. The physical space was similar. The same heavy wood paneling, the same formal arrangement of bench and tables. But the atmosphere was transformed. Judge Lydia Ortiz, recently appointed to fill the vacancy left by Sullivan's removal, listened attentively as Marcus presented arguments for the release of Deon Taylor, a young man sentenced to 12 years by Sullivan for a non-violent drug offense. The case exemplified Sullivan's disparate treatment. Taylor had received a sentence 4 times longer than what the prosecution had originally recommended, a deviation justified by Sullivan with boilerplate language about deterrence and community safety. In light of the documented pattern of judicial misconduct and the specific irregularities in Mr. Taylor's case, Marcus concluded, we respectfully request immediate release and expungement of this conviction. So District Attorney Hargrove, whose own reputation had been tarnished by his close association with Sullivan, offered only token opposition. While the state does not concede all of counsel's points, we acknowledge the procedural anomalies and do not object to the requested relief. Judge Ortiz, a former public defender whose appointment had been seen as a direct rebuke to Sullivan's legacy, nodded thoughtfully. Based on the review panel's findings and the recommendation of the special prosecutor, this court grants the motion for immediate release and expungement. She looked directly at Deon Taylor, who sat stunned beside Marcus. Mr. Taylor, The court apologizes for the injustice you have suffered. You are free to go." As Taylor embraced his weeping mother in the gallery, Marcus gathered his papers, feeling the familiar mixture of satisfaction and weariness that had characterized the past year. Taylor was the 87th defendant freed as a direct result of the Sullivan investigation, but hundreds more cases remained under review. Outside the courthouse, a small crowd of reporters awaited. The Sullivan scandal had initially dominated national headlines, then faded to periodic updates as the systematic review of cases proceeded. Today, with Taylor's release, interest had resurged. "Mr. Johnson," called a reporter from the Charleston Post and Courier, "do you have a comment on today's ruling?" Marcus paused on the courthouse steps. Today's decision represents another step toward rectifying the harm caused by corruption in our judicial system. But it's important to remember that for Mr. Taylor, the past 3 years of his life cannot be returned. True justice would mean preventing such abuses before they occur, not just remedying them afterward. "Do you think the reforms implemented since Judge Sullivan's arrest are sufficient?" asked another reporter. It was a question Marcus had considered deeply. The past year had seen significant changes in the Charleston judiciary: mandatory bias training, new transparency requirements for sentencing decisions, a diverse slate of judicial appointments, expanded oversight of prosecutorial conduct. Yet he remained acutely aware of how easily such reforms could be undermined or reversed once public attention waned. "The reforms are meaningful but incomplete," he answered carefully. "Changing policies is relatively straightforward. Changing culture, the unwritten rules and assumptions that guide daily decisions, is far more challenging. That work has only begun." As the impromptu press conference concluded, Marcus noticed a familiar figure waiting at the edge of the dispersing crowd: Special Agent Tanya Roberts. In the months since their initial collaboration, Roberts had become both a professional ally and a personal friend, someone who understood the complexities and contradictions of pursuing justice within flawed institutions. "Another victory," she observed as they walked together toward a nearby cafe. "A qualified one," Marcus replied. "Taylor lost 3 years. His mother lost her house trying to cover legal fees. His younger sister dropped out of college to work full-time supporting the family. How do we make that right?" Roberts sighed, a sound that acknowledged the inadequacy of available remedies. "The civil settlements will help financially, at least. And the federal investigation into the private prison kickback scheme is making progress. Indictments expected next month." They found a quiet table in the back of the cafe, ordered coffee, and compared notes on the various strands of the still-expanding investigation. Sullivan herself had pleaded guilty to reduce charges in exchange for cooperation against higher-profile targets, receiving a 10-year sentence that many, including Marcus, felt insufficient given the scope of her crimes. "Have you thought more about the judgeship?" Roberts asked after their updates concluded. The question touched on a possibility that had emerged unexpectedly in recent weeks: an opening on the federal bench, with Marcus's name circulating as a potential nominee. The idea had been simultaneously flattering and troubling, prompting deep reflection on his role in the justice system. "Every day," Marcus admitted. "I'm still not sure it's the right move." "Because?" "Because I've spent my career fighting from the outside. Being on the bench means working within the system in a different way. It means constraints, compromises, limitations. I'm not sure I can accept." Roberts considered this. "True. But it also means the power to make different decisions than Sullivan made, to set different precedents, to demonstrate what justice can look like when administered fairly. If I have that freedom, The system has ways of disciplining judges who stray too far from accepted practices. It does, Roberts agreed. But systems change when enough people within them make different choices. Look at what you've accomplished already. Their conversation was interrupted by Marcus's phone, a text from Rebecca with a link to a breaking news story. Marcus opened it, his expression shifting from curiosity to disbelief as he read. "What is it?" Roberts asked, noting the change. "They found Sullivan's records," Marcus said, his voice hushed despite the privacy of their corner table. "The ones everyone suspected existed but couldn't locate." He turned the phone so Roberts could see the headline. "Hidden Archives. Former judges' secret scorecards reveal decades of judicial targeting." According to the article, a maintenance worker renovating Sullivan's former private chambers had discovered a false wall containing dozens of notebooks meticulously documenting her deliberate manipulation of cases. The journals included coded ratings for attorneys, particularly noting those who were Black or who represented predominantly Black clients, with explicit strategies for undermining their cases. "This is beyond what we suspected," Marcus said, scanning the details. "She wasn't just biased. She was systematically tracking and targeting specific attorneys, including me." He paused at a particularly disturbing passage. "Look at this. She writes about deliberately scheduling my cases before holidays or late in the day when juries would be impatient, about selectively enforcing time limits on my arguments, but not on the prosecutions." Roberts's professional composure momentarily slipped. "My God," she murmured. "This is a smoking gun for the civil rights cases, and vindication for every attorney who ever felt they couldn't get a fair hearing in her courtroom," Marcus added, already thinking of colleagues whose careers had been derailed after challenging Sullivan. As they continued reading, the article revealed even more disturbing information. Sullivan had maintained a point system, awarding herself higher scores for harsher sentences given to minority defendants. She had tracked which prosecutors were reliable in helping maintain this system and which ones needed to be educated or avoided. She had even recorded conversations with other judges where they discussed ways to insulate their biased practices from appellate review. "This changes everything," Marcus said. "The scope of the review will need to expand significantly. Every case she ever handled is now suspect. And it implicates others on the bench," Roberts noted grimly. "Those conversations she recorded weren't one-sided." The discovery of Sullivan's records sent shockwaves through Charleston's legal community and beyond. National media descended on the city once again, and the Department of Justice announced an expanded investigation into systemic discrimination in South Carolina's courts. For Marcus, the revelations brought both validation and a renewed sense of purpose. 3 days after the notebooks became public, he received a call from Chief Justice Lorenzo Williams of the state Supreme Court, requesting an urgent meeting. The following morning found Marcus in the Chief Justice's chambers in Columbia, the state capital, seated across from the man whose leadership would determine how the judiciary responded to this institutional crisis. Chief Justice Williams, at 70, had earned respect across the political spectrum for his intellectual rigor and personal integrity. A moderate conservative with a reputation for fairness, he had been initially skeptical of the extent of Sullivan's misconduct, but had shown increasing concern as evidence accumulated. "Thank you for coming, Mr. Johnson," Williams began, his deep voice matching his imposing physical presence. "I wanted to speak with you directly about where we go from here." Marcus nodded respectfully, waiting for the justice to continue. "These notebooks," Williams said, gesturing to copies spread across his desk, "represent a betrayal of everything the judiciary is supposed to stand for. Sullivan didn't just violate her oath. She made a mockery of it, year after year, case after case. Yes, Your Honor, Marcus agreed. The systematic nature of the discrimination is what's most disturbing. Williams leaned forward, his expression grave. What's most disturbing to me, Mr. Johnson, is that it went unchecked for so long. That colleagues, attorneys, court staff, all of us, failed to stop it. The frank acknowledgement of collective responsibility surprised Marcus. The system protects its own, he observed carefully. It does, Williams conceded. Often for good reasons. Judicial independence is vital to our function. But we've allowed that principle to shield conduct that undermines the very purpose of an independent judiciary. He paused, seeming to choose his next words with deliberation. I've spent the past 48 hours reviewing your career, Mr. Johnson. Your cases, your advocacy, the concerns you raised about Sullivan that were repeatedly dismissed. Marcus felt a flicker of unease. May I ask why? Because I'm trying to understand how we failed so completely. You saw what was happening. You documented it. You pursued proper channels for years before taking more drastic action. And at every step, the system, my system, brushed you aside. The conversation shifted then, moving from the specifics of Sullivan's misconduct to broader questions about institutional reform. Williams outlined proposals for a comprehensive audit of sentencing patterns across the state, for new whistleblower protections specific to judicial misconduct, for diversifying the bench not just in terms of demographics, but in professional background. These are significant changes, Marcus noted. Will they have support from the rest of the court? Williams smiled wryly. Not universally, no. Change never comes without resistance, especially in an institution as tradition-bound as ours. But Sullivan's notebooks have created a moment of reckoning that even the most reluctant members of the bench cannot ignore. As their meeting concluded, Williams asked the question that had been hovering unspoken throughout their conversation. Have you considered the federal judgeship, Mr. Johnson? Your nomination has support in Washington. I have, Marcus acknowledged. I'm still weighing whether I can be more effective on the bench or continuing as I am now. Williams nodded thoughtfully. A fair question. But consider this. Reform from within requires people who understand what needs to change. The bench needs your perspective, especially now. Driving back to Charleston, Marcus reflected on the Chief Justice's words and the extraordinary series of events that had led to this moment. He had begun his career believing that working within the system, filing the right motions, making the proper arguments, respecting procedural norms, would eventually yield justice. Experience had taught him otherwise, pushing him toward more confrontational approaches when conventional methods failed. The discovery of Sullivan's notebooks, however, had created an unexpected opening, a rare moment when institutions were genuinely receptive to structural change. The question he now faced was how best to leverage that opening, as an advocate pressing from outside or as a judge working from within. 2 weeks after the notebooks became public, Marcus sat in his home study late into the night, surrounded by case files, reform proposals, and personal notes accumulated over months of work on Sullivan-related cases. Angela found him there, staring at a document on his computer screen, his formal response to the Judicial Nomination Committee. Still uncertain? She asked, placing a cup of tea beside him. Marcus sighed, running a hand over his face. I keep coming back to the same question. Where can I do the most good? Angela pulled up a chair beside him. Tell me your concerns, all of them. If I become a judge, I gain certain powers but lose others. I can't choose my cases. I can't advocate as freely. I'll be bound by precedent even when I disagree with it. And let's be honest, I'll face scrutiny and resistance that white judges don't experience." "All true," Angela acknowledged. "And the arguments in favor?" Marcus gestured toward a stack of files. "Every one of these is a life affected by Sullivan's corruption. As a judge, I could ensure those kinds of abuses don't happen in my courtroom. I could establish different precedents, demonstrate what fair application of the law actually looks like." "You could be the judge you wished Sullivan had been," Angela observed. "Yes. But is that enough? Sullivan was one judge in one courthouse. The problems are systemic, not individual." Angela considered this. Maybe it's not an either-or question. Thurgood Marshall changed more as a Supreme Court justice than he could have as even the most brilliant advocate. "I'm not Marshall," Marcus said with a small smile. "No, but the principle stands. Different roles offer different opportunities for change. The question isn't which is more important. It's which aligns better with your specific strengths and the current moment." They talked late into the night, weighing options, considering implications. By morning, Marcus had made his decision. The formal investiture ceremony for the Honorable Marcus Johnson, newly appointed to the United States District Court for the District of South Carolina, took place on a crisp autumn day 18 months after Sullivan's arrest. The federal courthouse in Charleston was filled beyond capacity, with an overflow room set up to accommodate those who couldn't fit in the main courtroom. As Marcus took the oath, administered by Chief Justice Williams, he was acutely aware of the journey that had brought him to this moment. From the young attorney frustrated by Sullivan's bias, to the catalyst for her downfall, to her successor, in a sense, though on a different bench. Among those present were James Wilson, now working as a paralegal while pursuing a degree in criminal justice; Dion Taylor, whose release had marked a turning point in the review process; and dozens of other former defendants whose cases had been overturned following the Sullivan investigation. Their presence was a powerful reminder of the human cost of judicial misconduct and the transformative potential of reform. Special Agent Roberts sat in the front row beside Rebecca Chen, who had joined Marcus's former law partner in continuing to represent clients affected by Sullivan's actions. Terrence Washington, recently appointed to the State Circuit Court, beamed with pride as his mentor and friend assumed the federal bench. Most meaningful to Marcus was the presence of his parents, his father, now retired from the Postal Service, and his mother, whose early lessons about justice had shaped his understanding of the law. They had witnessed his struggles against a system designed to marginalize voices like his, had supported him through disappointments and victories, and now watched as he took on a role few from their community had ever held. In his remarks following the oath, Marcus acknowledged the complex mix of emotions the occasion inspired. "I stand before you today with profound gratitude and equally profound awareness of the responsibility this position entails," he began. "The path that led me here was neither straight nor easy. It revealed both the resilience of our legal institutions and their capacity for devastating failure." He paused, looking out at the assembled crowd, colleagues, friends, family, and many whose lives had been directly impacted by the Sullivan case. Judge Eleanor Sullivan's misconduct represents one of the darkest chapters in our state's judicial history. But the story doesn't end with her removal or even with the remediation of cases she corrupted. The true test of our commitment to justice lies in what we build in the aftermath, the safeguards we establish, the reforms we implement, and perhaps most importantly, the voices we include in shaping the future of our courts. Marcus spoke about the ongoing work of the review panel, which had expanded to examine cases from other judges implicated in Sullivan's notebooks. He discussed the legislative reforms that had emerged in response to the scandal, including new requirements for transparency in sentencing and enhanced oversight of judicial conduct. He acknowledged the victims of Sullivan's corruption, many of whom had lost years of their lives to unjust incarceration. As I assume this position, he continued, I do so with no illusions about the challenges ahead. The same system that allowed Judge Sullivan to operate unchecked for 24 years remains in place, albeit with new safeguards. The biases that influenced her decisions did not originate with her, and did not end with her removal. His voice grew stronger, more resolute. But I also stand here with hope. Hope grounded in the remarkable changes we've already witnessed. Hope inspired by the courage of those who spoke out despite personal risk. Hope sustained by a new generation of legal professionals committed to justice in its truest sense. As the ceremony concluded and well-wishers gathered around the new judge, James Wilson approached, extending his hand. "Congratulations, Your Honor," he said with a smile. "Or is that weird to say since you were my lawyer?" Marcus laughed. "A little weird, yes, but thank you." Wilson's expression grew more serious. "Do you think it will stick? All these changes, I mean. Or will things go back to how they were once people forget about Sullivan?" It was the question that had kept Marcus awake many nights as he considered accepting the nomination, whether the reforms born from scandal would endure once public attention inevitably shifted elsewhere. "Some changes are already permanent," Marcus answered thoughtfully. "The people released from unjust sentences, the cases overturned, the careers salvaged, those can't be undone. Other reforms will face resistance, attempts to water them down or circumvent them. That's the nature of institutional change." "So what makes the difference?" Wilson pressed. "What determines which changes last?" Marcus considered the young man before him, once a defendant in Sullivan's courtroom, now an advocate in his own right, pursuing education that would further empower his voice. "Vigilance," Marcus replied. "Continued pressure from inside and outside the system. New voices in positions of authority who bring different perspectives and priorities. And perhaps most importantly, public awareness. Citizens who understand that justice isn't an abstraction, but a daily practice that affects real lives." Wilson nodded, seeming satisfied with this answer. "Well, I'm doing my part. 3 of us from the class action suit started a monitoring project, tracking sentencing patterns across the state, identifying disparities, publishing the data." "That's exactly the kind of oversight we need," Marcus said, genuinely impressed. As the crowd gradually dispersed, Marcus found himself standing alone for a moment in the courtroom that would now be his domain. The weight of the responsibility settled on his shoulders, not just to decide individual cases fairly, but to help rebuild trust in institutions that had betrayed that trust repeatedly. He thought of Eleanor Sullivan, currently serving her sentence in a federal prison in Florida. The woman whose cruelty and corruption had caused immeasurable harm had inadvertently created the conditions for transformation. It wasn't the justice Marcus would have designed. Too many lives had been damaged in the process. But it was the justice that had emerged from persistent advocacy and unexpected revelations. Tomorrow would bring his first full day on the bench, the beginning of a new chapter in his lifelong commitment to justice. There would be difficult cases, institutional resistance, and the constant challenge of applying flawed laws as fairly as possible. But there would also be opportunities to demonstrate what the law could be when administered with integrity and equal regard for all who appeared before the court. As Marcus gathered his robes and prepared to leave, Angela joined him, slipping her hand into his. "Ready for what comes next?" she asked. Marcus looked around the courtroom once more, then back to his wife. "As ready as anyone can be," he replied, echoing the words he had spoken to Terrence Washington on the day he confronted Sullivan. "This isn't the end of the story, it's just the beginning of a new chapter." The annual conference on judicial ethics had once been a perfunctory affair, sparsely attended, minimally covered by legal publications, generally viewed as a bureaucratic requirement rather than a meaningful forum. In the wake of the Sullivan scandal, however, it had transformed into one of the most significant gatherings in the legal calendar, drawing judges, attorneys, academics, and advocates from across the country. Judge Marcus Johnson, now in his 5th year on the federal bench, had become a regular speaker at the conference, known for his forthright discussions of bias, accountability, and the ongoing work of institutional reform. His courtroom had earned a reputation for rigorous adherence to procedural fairness, while his written opinions, often cited by other courts, reflected both scholarly depth and practical wisdom. This year's conference, held in Washington, D.C., featured a panel discussion titled After Sullivan: Lessons Learned and Challenges Ahead. Marcus shared the stage with Justice Elaine Washington from the South Carolina Supreme Court, Professor Daniel Levinson, whose statistical analysis of judicial decision-making had become a standard tool for identifying potential bias, and James Wilson, now an attorney with the Civil Rights Division of the Department of Justice. The audience included judges at various stages of their careers, from recently appointed state court judges to veterans of the federal bench. Among them sat Vanessa Miller, the former prosecutor who had worked under District Attorney Hargrove during Sullivan's reign. After the scandal broke, Miller had testified about the pressure prosecutors faced to tailor their cases to Sullivan's expectations, then left the DA's office to join a criminal defense firm specializing in wrongful conviction cases. As the panel discussion concluded and attendees mingled during a reception, Miller approached Marcus with a folder in hand. "Judge Johnson," she said, "I wanted to share this with you personally. It's the final report on the Sullivan Review Project." The project, established in the immediate aftermath of Sullivan's arrest, had spent 5 years methodically examining every case over which she had presided. Its work had resulted in hundreds of overturned convictions, modified sentences, and civil settlements for those wrongfully incarcerated. 5 years, 473 cases reviewed, 218 convictions vacated, 142 sentences reduced, Miller summarized as Marcus scanned the document. And perhaps most importantly, 17 reforms implemented at the state level, with another 9 pending in the legislature. Marcus closed the folder, deeply moved by the tangible evidence of progress. "This represents incredible work, Vanessa. You and your team have made a real difference." "We had a strong foundation to build on," she replied. "The groundwork you laid made all of this possible." As they discussed specific cases and reforms, they were joined by Chief Justice Lorenzo Williams, now in his final year before mandatory retirement. Williams had become an unexpected ally in the reform movement, using his authority to implement changes that might have taken years through legislative channels. "I just came from a meeting with the Judicial Selection Committee," Williams announced, his expression suggesting good news. "They've approved the new diversity requirements for judicial nominees. Starting next month, selection panels must include community representatives from areas most impacted by judicial decisions." This change, which Marcus had advocated since his first days on the bench, would help ensure that judicial appointments reflected a broader range of experiences and perspectives. A small but significant step toward courts that truly represented the communities they served. "That's excellent news," Marcus said, "though I imagine it wasn't unanimously supported." Williams chuckled. "Not remotely. Judge Carlton practically turned purple at the suggestion that we need input from non-legal professionals," as he put it. But the Sullivan case has given reformers leverage we never had before. Even the staunchest traditionalists recognize that the old ways of doing things are no longer tenable. As the evening progressed, Marcus reflected on the distance traveled since that fateful day in Sullivan's courtroom. The changes had been neither as comprehensive as he'd hoped, nor as superficial as he'd feared. Real progress had been made in legislation, in judicial practice, in public awareness. Yet much remained unchanged, particularly in jurisdictions less directly affected by the Sullivan scandal. Later, as he prepared to leave the conference, Marcus encountered a young law clerk who had attended his session. The clerk, a black woman in her late 20s, approached with the tentative respect of someone addressing a federal judge, but also with the directness of a generation less constrained by traditional hierarchies. "Judge Johnson," she began, "your discussion today about implicit bias in judicial decision-making was incredibly powerful. But I wondered, do you ever worry that by becoming part of the system, you've had to compromise more than you intended?" It was a perceptive question, one that Marcus himself had wrestled with throughout his tenure on the bench. There had indeed been compromises, moments when the constraints of his position limited what he could say or do. There had been cases where precedent required outcomes he personally found troubling, where the letter of the law seemed at odds with its spirit. "I do worry about that," he acknowledged candidly. "The system shapes all who participate in it, including those who enter with the intention of changing it. But I've found that influence runs in both directions. Yes, I've had to accept certain limitations, but I've also had opportunities to nudge the institution toward greater fairness in ways that wouldn't have been possible from the outside." The clerk nodded thoughtfully. "I'm considering whether to apply for a judgeship eventually or focus on impact litigation. It's hard to know which path offers more potential for meaningful change." "Both are essential," Marcus replied. "The reform of any institution requires pressure from multiple directions, internal and external, gradual and disruptive, individual and collective. The question isn't which approach is better in absolute terms, but which aligns with your particular skills and circumstances." As he offered this advice, Marcus was struck by how closely it echoed his conversation with Angela years earlier, when he was wrestling with the same decision. The cyclical nature of these questions, each generation confronting similar dilemmas in new contexts, reminded him that the work of justice was never complete, only advanced incrementally through the efforts of those committed to its principles. The following morning, before leaving Washington, Marcus visited the National Museum of African American History and Culture. In a quiet corner of the Defending Freedom, Defining Freedom exhibition, he paused before a display about the legal challenges to segregation. The exhibit included information about legendary civil rights attorneys, alongside less famous figures who had contributed to the long struggle for equal justice. A new addition to the exhibit caught his attention. A small section dedicated to the Sullivan case, featuring documents, photographs, and a brief description of how one corrupt judge's exposure had led to broader systemic reforms. The display included a quote from Marcus himself, taken from an interview he had given shortly after joining the federal bench. "Justice is not an achievement to be completed, but a practice to be continually refined. Each generation inherits both the progress and the failures of those who came before, with the responsibility to extend the former and address the latter." Standing before these words, Marcus felt the dual weight of what had been accomplished and what remained to be done. The Sullivan case had created an opening for change that many had worked diligently to exploit, resulting in concrete improvements to the administration of justice. Yet fundamental inequities persisted, both in South Carolina and across the country. As he prepared to return to Charleston and resume his duties on the bench, Marcus carried with him this tension between achievement and aspiration, between the real progress that had been made and the ideal of justice that remained elusive. It was a tension that defined his work, his life, and the ongoing struggle to ensure that the law's promise of equal justice was fulfilled for all who sought its protection. In his courtroom the following Monday, as he called the first case on his docket, Marcus looked out at the assembled attorneys, litigants, and observers. Each person present carried their own history, their own understanding of justice and injustice, their own expectations of what would unfold in this space dedicated to the resolution of conflicts according to law. "Court is now in session," the bailiff announced, and Judge Marcus Johnson took his seat at the bench, ready to continue the work that had begun long before Sullivan's exposure and would continue long after, the daily, deliberate practice of justice with all its imperfections and all its possibilities.